The longest serving president in the Big 12, the second longest serving in the history of the University of Oklahoma. He displays an energy and enthusiasm for growth and improvement that continues to be example to us all. He consistently advocates the needs of the university, enabling it to grow both in size and in stature. No other public university in America has made greater progress, and he is the reason behind it. Our campuses have been physically transformed, our students have more resources for learning, our faculty strengthened and invigorated, and our spirit is wonderfully strong. Please help me in welcoming an OU College of Law alumnus in the class of 1968, President David Morton.
I have an unusual privilege today to introduce our special guest and also be here with the Dean. It's interesting for me because both of them, during their college days, were interns in my U.S. Senate office in Washington. And they're, 19, 20 years old. So if any of you, students particularly, would like to know anything about the Dean during those years or a guest speaker, I know a lot about both of them. Some children are here today, so I've been told, of the speaker, I've been told not to even refer to such knowledge as I might have. And it's also a privilege for me because the friendship between the Raley family and our family goes back so far. It goes back to John's grandfather, who was in essence the founder of Oklahoma Baptist University, and his friendship with my father, a lot of things they did together, like, and totally without authorization, bringing several truckloads of brick from McAllister Penitentiary to build buildings with at OBU, a private religious university. We won't go into the constitutional issues, let alone the property issues that were violated when they worked together in a good and just cause. And also, both of John's parents are here today, and they both helped me become governor. And when John was serving as a U.S. attorney, having been appointed by President Bush Sr., and I went to the Senate, John Raley, who's here with us today, was the only U.S. attorney in the Clinton administration carried over from the Republican administration. So it was my privilege to recommend that he be kept. So I was responsible for appointing the only Republican U.S. attorney during the whole administration of President Clinton. And I'm still very proud of that. And I think you'll understand my pride because you'll see reflected in John Raley's remarks today the values that have been passed on to him through his family. And it was my privilege to also know his grandmother extremely well. Every day you come into the law school, you cannot escape the words because they're chiseled in the floor of every entrance. And because I think these are words all of us, whether we're guests at the law school or whether we're students or faculty or staff at the law school, need to reflect upon. And they say when we allow the rights of any one person to be violated, we put at risk the rights of all of us. And I think that's something that this particular case sums up and makes dramatic to us. I also said in freshman convocation this year and last year that if I had any hopes for our graduates, of course I hope for their financial and professional success because they will later become generous donors to the College of Law. But more than that, I hope to hear in the media and to see in the media reports that when someone is doing pro bono work, someone is providing representation for the underprivileged that otherwise would not have the kind of talent that you would bring to the case, that I will read that story or hear that story, and it will be a graduate of the College of Law that will be involved. Then I will feel that our college is doing what it should do. Then I will have deep pride in what has been produced by your educational experience at the College of Law. It's an obligation and an opportunity, rewarding opportunity when services are provided to those that otherwise do not have legal representation. I know OU law students believe this, and you've shown that. This last year you performed more than 10,000 hours of pro bono service. Our guest today is a graduate of the College of Law. He is a Houston-based trial lawyer with almost 25 years of courtroom experience. He first came after graduating from law school to Houston to work for Fulbright and Jaworski, where he worked for almost 17 years. He now has his own firm, Raley & Bowick, which is a boutique firm dealing with several areas of specialization. His clients range from Fortune 500 companies to individuals. And he's tried cases in a variety of areas, including intellectual property, legal malpractice, products liability, pharmaceutical claims, and in this case, in an odd way, an area of specialty that brought him into this case, because he is not a criminal lawyer. This is one of the most interesting aspects of this case. This is the only criminal case in which he has ever been involved, and I can't think of any more important one. And it came in part because of his involvement in cases involving medical malpractice, hospital and physician malpractice, and it gave him a certain area of expertise, an understanding of DNA testing that went beyond that of most attorneys, and it's what drew him into this case to provide representation for the accused, who you have already met, Michael Morton, who spent as an innocent person charged with the death of his wonderful wife, spent 25 terribly difficult years incarcerated. You can imagine the impact that it had in terms of his relationship with his family and with his children and others. Mr. Raley has had more than 30 victorious first-chair verdicts. He's handled more than 150 mediations as lead counsel. He obtained his bachelor's degree with highest honors from OU as an undergraduate, then graduated from the College of Law in 1984, then attended the University of Aberdeen in Scotland on a Rotary Fellowship and obtained an LLM in International Law in 1988. 7 years during which he provided pro bono representation for Mr. Morton led to his release, as I mentioned, after serving 25 years. And his efforts also have now led to the arrest and indictment of the person who truly was responsible for this heinous crime, the murder of Mr. Morton's wife. This case has been talked about and written about across the country. In fact, as I was driving along one day on my way to Oklahoma City, I was listening to NPR News. Maybe it was All Things Considered, and I heard a discussion of this case. And then all of a sudden I heard the name John Raley associated with it. And I sat up and took notice and listened very carefully to the rest of the program. But you'll be seeing more about it on 60 Minutes in the near future. His tenacious fight to help an innocent man and secure his release from prison represents the very best values of our College of Law. So we are really, really pleased to have John Raley back home with us and to have him talk about this remarkable case. John, very glad you're here.
Thank you very much, President Ford. I am delighted to be here with my family, my father, my mother, their spouses, my daughter Kate, who's a sophomore. And I'm particularly pleased to be here with my dear friend and brother, Michael Morton, who have made a special effort to drive here to be a part of this today. I have very fond memories of this room. I remember sitting right over there in that corner 31 years ago, my first year in law school, laughing and telling jokes with my friends while other students talked about fine points of law. And I remember standing right over there a year later in the final round of the moot court competition, wishing that I too had joined in some of those discussions of law, but it was too late. A few years after that, when I was enjoying my zealous young lawyer days in Houston, Michael Morton, a mild-mannered manager of the local Safeway in North Austin, on August 13th, 1986, kissed his wife goodbye at 5:30 in the morning and went to work. They celebrated his birthday the night before with their 3.5-year-old son, Eric, who was just down the hallway sleeping when Michael left for work. And it was a normal day at work. Nothing unusual until he went to pick up Eric from daycare early that afternoon. They had their days staggered so that Christine would drop him off first and then Michael would pick him up. Eric was not brought to daycare that day. Michael called home. Sheriff Boutwell answered the phone. He said, "You need to come straight home." Michael hurried home, his heart pounding, to see yellow tape all the way around his house. A few hours earlier, his wife was horribly murdered, and the murder scene was gruesome. She was bludgeoned to death in her bed with a blunt instrument. There was blood all over the walls, the ceiling, bits of flesh against the walls. The monster who did this must have continued to beat her long after she was dead. Michael's first question was, "My little boy okay?" And he was. Michael answered all of their questions. No lawyer. He signed a permission for them to search, even though they had very carefully searched for hours without calling him to tell him that his wife was dead. Yes, that was his note on the bathroom mirror saying, "You really left me hanging last night on my birthday." He wanted to celebrate his birthday in an amorous fashion, and she was tired and said, "Tomorrow night," and sounds kind of like a typical American family. But that note became very important later. They found that Christine's purse was stolen, Michael's gun was stolen. Later they would accuse him of staging those things. I think that the murderer saw Eric in his diaper and made some sort of decision not to kill him, but thought, screw it, and grabbed what he could grab quickly and ran. There was a bandana containing Christine's blood. Apparently he wiped her blood off his face and hands and stuck it in his back pocket and ran through an abandoned construction area behind the house. Nobody knew it was Christine's blood because they didn't test it until 2011. So our whole fight was to try to get this bandana tested and other things. It was about 100 yards behind the house, but we always said that was his escape route. And indeed, there was a footprint right there at the privacy fence in the mud that nobody made a plaster cast of. It was a man's footprint. There were strange fingerprints on the sliding glass door, which was left unlocked, unfortunately, and on the luggage that was piled on Christine's body, but those hadn't been run either. There was, the sheets were all bloody, and of course, during the murder, Christine would have been reaching for the sheets, so she had a hair in her hand that appeared to be Michael's hair. Not that unusual. He slept in that bed. It probably was going to be Christine's or Michael's. But if it was someone else's, that would be significant. There was an old semen stain, which the state lab wrongly said was a neat stain, containing only male cells, no female cells, no backwash from normal intercourse. That will be important as well. They came up with the theory that Michael killed Christine in a sex-filled rage because she did not have sex with him the night before on his birthday. And so in this rage, he bludgeoned her to death. And then, evil man that he was, he left his 3.5-year-old boy to walk around his wife's corpse all day until it was discovered. So, without any real evidence against him, and he'd passed 2 lie detector tests by now, they came to arrest Michael at his house. And he was holding Eric when they came. They brought a female police officer to take Eric out of his hands as they handcuffed Michael and led him away. He looked back and saw his son reaching for him and crying, "Daddy, Daddy," as he was led away. He was tried in the spring of 1987 under this theory of the sex-filled rage. They said because of this neat, so-called neat, old semen stain, that he had killed her, and then, and here's where we lose our PG-13 rating. that he masturbated over her corpse using her hand to do it with. A theory guaranteed to inflame a jury. They also offered evidence of stomach contents timing of death, which all the medical literature at the time says you cannot do, that it's alchemy. But they called a pathologist named Bayardo, who didn't even put it in his pathological report because he says, I never do that. And he said that originally, this is interesting, he timed the death as late as 6 a.m., which would be perfectly consistent with the murderer watching Michael leave and then coming in after Michael left. But after further consultation with the prosecutor, he changed his time to before Michael left. Remember, he didn't see the body for 2 days. There was no rigor mortis, there was no liver mortis, there was nothing. It was just stomach contents, which vary so much between people and even within people, depending on the kind of mood you're in, how quickly you digest. So he opined at trial that the death was before Michael left. But, he said, that's not a scientific opinion. Quote, now, you've studied Daubert in law school, but even before Daubert, if an expert witness says that's not a scientific opinion, it's not supposed to come into evidence. But it did. He admitted under cross-examination, there is no scientifically precise way to time death based on stomach contents alone. Again, it shouldn't have even been before the jury. But on rebuttal of closing argument, when the defense lawyer couldn't even respond, the prosecutor said 6 times, I counted them, medical science proves Michael Morton is the killer. It happened before he left. There was no one else who could have done it. And look at these pictures of what he did. How horrible. Look at what's left of her face. This monster did this. And then he left his son there, around his wife's corpse. Jury was not out very long. What neither the court nor the defense lawyers knew at the time was that the prosecutor, Ken Anderson, District Attorney of Williamson County, Texas, now sitting District Judge Ken Anderson, and his team had concealed the evidence of Michael's innocence. And it was buried like a time capsule for 25 years until we found it in a Freedom of Information Act request. I'll talk about that in just a second. Eric was raised by his mother's sister to believe that his father killed his mother. And so the annual, sometimes semi-annual prison visits for an hour to see his father were very strained and uncomfortable. And then when he was 13, Eric asked to stop seeing his father, and his father reluctantly agreed. And then when he was 18, Eric legally changed his name to no longer be Eric Morton. And Michael's personal story about that, the low point of his life, because when you're in prison, to live, you have to have something to cling to outside of prison that you can see. But when that was taken away, he was ready to die. And how God ministered to him and helped him to survive is his story, and I won't tell it, but when he tells it, I urge you to listen to it because it's very profound. So, in 2000, there was a DNA test on the semen stain. It confirmed that it was not a neat stain. It contained pristine cells as well. It was from normal marital intercourse several days before the murder. I got a call in 2004. Not a criminal defense lawyer. My father's a retired prosecutor, U.S. attorney. My brother's currently a prosecutor. But I don't know anything about criminal law. I've had to learn a lot. But they were interested in this stomach contents analysis, and they thought a med-mal lawyer might be useful. So the Innocence Project of New York called me and said, will you take this case pro bono? They said, you you won't be paid anything, and if you do a great job, we'll send you another. I mean, that's kind of the way it worked for them. But I knew their name, and I knew their work, and I was honored to take the case. I had no idea that it would be this extensive or this long. I read the trial file as a trial lawyer, and I could see that there was really no evidence against this guy. Nothing to support a conviction. I visited him in prison, and I can't claim to have psychic power, but I cross-examine people for a living, and I have a pretty good sense when people are fibbing. And I came home to my wife, Kelly, and I said, you know, my God, this man is innocent. We've got to get him out. So we worked, and on February of 2005, 7 years ago, Michael, we filed the motion for DNA testing. Bandana, #1 item. And we argued this could have Christine's blood and the DNA by sweat and skin cells of a man who is not Michael Morton, or woman, who might hit through the national data banks to link to a known offender, because there are millions of potential people in the DNA data banks. We wanted the hair tested under the off chance that it wasn't Michael's or Christine's. Swabs and fingernail clippings in case she, in trying to fight, scratched his skin cells. We wanted the fingerprints run, which the statute does not provide for, but you know, it just makes sense, right? And we wanted a comparison to the McKinney murder 7/10 of a mile away before the Mortons moved in. Mildred McKinney was also killed in her bedroom. So those two latter things were long shots. Under the advice of my father, retired prosecutor, I just, it's amazing that I thought this might have a chance of working. I just called the district attorney to see if he would agree to the test, or at least not oppose it, so that we could, you know, kind of walk it through in an agreed motion. And he said no. And I said, why? And he said, it would muddy the waters. And I paused and I said, Mr. Bradley, truth clarifies. So the battle was engaged. I drove to Georgetown to try to meet with him to see if I could persuade him. And he said, okay, here's the deal. We'll let you test the hair, but only if you agree to not test anything else. And I said, no. How stupid do you think I am? It's probably Michael's hair or Christine's. It's only unusual if it's someone else's. Why won't you just test the whole thing? And he says, well, what if the results came out against your client? I go, that's easy. I'd call him up and say, Michael, I've got some bad news for you. Test results came out against you. Now, Mr. Bradley, let me turn it on you, because what would you do if they exonerated him? I don't want to go Jack Nicholson on you, but I can handle the truth. Can you, sir? Many delays by the district attorney's office, many requested extensions by the district attorney's office, which were always granted. Finally, they responded. They fought everything. The bandana they fought the very hardest. They said it was too far away from the crime scene, missing the whole point that that's the key. If it's on his escape route, then he dropped it as he ran. I can almost see it in his back pocket, falling out as he's running away. And it's just a miracle that it was preserved and hermetically sealed all these years. And the DNA is still on it. Meanwhile, in the media, because the media is starting to get attention in this case, the district attorney is belittling us. He said that we were silly. He said that we were grasping at straws. He made fun of us for searching for a mystery killer. In the fall of 2006, our motion was granted as to the easy things, the swabs, the fingernail clippings, denied as to the bandana, and the McKinney comparison and the fingerprint request not mentioned in the order. Realizing that there might be some sort of a gambit afoot, we immediately wrote a letter to the judge saying, Your Honor, we recognize that you have not ruled on everything before the court. You may want to rule on that later after the swabs and fingerprints are tested. But, you know, we still have out there the fingerprints and the McKinney. I mean, after the fingernail clippings are tested, you may want to rule on these other things. Meanwhile, we got tired of messing around with state courts, so we sued the district attorney in federal court in Austin, which was fun but didn't last long. The federal judge, when I was arguing, he said, "What do you expect me to do? Order a state judge to test DNA?" And I said, "Yes, you've got it. That's exactly right." And he said, "Well, I can't do that. We have two courts that are working on this, and I can't intervene and take his jurisdiction." Although he had a wonderful little comment at the end of his opinion, dismissing my federal case, saying, "I don't really have jurisdiction, but I don't understand why the district attorney of Williamson County doesn't just agree to this, given that he has a duty to justice and the Constitution of the United States of America." Love, Sam Sparks. So if you get a case dismissed with that kind of stuff, it was still worth it, you know. So early of 08, let's see, we get our results in. The hair is Michael's, no surprise there. Nothing in the fingernail clippings we can use. Now it's time to appeal the bandana. But here's your criminal procedure question. The district attorney says, you can't appeal the denial of the bandana. Why? He says, you've waived it. Over 30 days have passed since, and I never told you this, Michael, because I didn't want you to worry. But there's a word that lawyers hate more than any other word, and the word is waiver. It's a very scary word. And he was trying to say that we had waived the right to appeal the bandana testing because we didn't do it within 30 days. And we went, hold on. You haven't ruled your... What's the answer, criminal procedure students? Anybody want to go? He has to rule on everything before him before it's a final judgment for the purpose of appeal. You can't appeal an incomplete judgment. We had no possibility of appealing, and therefore we couldn't have waived it. We had a hearing in March of 08, the first hearing I'd gotten, and I poured my heart out, and I said, Your Honor, you have to sign an order denying my motion so that I can appeal it. He says, well, I think it's implicitly denied. I said, no, Judge, I can show you a bunch of cases. You can't implicitly deny a motion. It has to be granted or denied, and you have to put it in writing so that we can have appellate review. Period. That's the law. He didn't agree with my interpretation of the law. And so we had to appeal that. But while we were there, I remember saying, Judge, if we test this, at least at the end of our days, we'll be able to say, we did all we could to find the truth. And if we don't, we'll never be able to say that. I just don't understand how there could be such opposition to something that would be free to the state of Texas, because the Innocence Project would pay for it, and only reveal the truth. So our first appeal was to mandamus the judge to order him to sign an order denying our motion so that we could appeal that. So the Court of Appeals ordered him to sign an order. He dutifully denied our motion. Then we appealed that. More delays. Meanwhile, I catch Michael in one of our phone calls just to give him an update, and he tells me, you know, John, they've offered me a parole. And I said, that's great. And he said, but they said I have to show remorse for my crime. And I thought, oh, I couldn't advise him, because I don't know what I would do. I might say, if I didn't have Michael Morton's character, I might say, yeah, I'm really sorry, let me go. I've been here 23 years, the system's failed me. I'm sorry, I'm really sorry, let me go. I said, Michael, what are you going to do? And he said, all I have left is my actual innocence. And if I have to be in prison the rest of my life, I'm not giving that up. And I just felt this swell of emotion. And I said, Michael, I promise you I will never quit. As long as I'm breathing air, I'm trying to get you out of there. And we hung up the phone, and my friend with the Innocence Project, Nina Morton, goes, why are you saying that? You know, what if there's no DNA? And I said, I will never quit. I don't care. We'll find something. He's innocent. Freedom, let's see. So, we won the appeal. The bandana's going to be tested, but it wasn't over yet. The DA still wanted DPS to test it, even though they'd written a letter saying we don't have the technology to do these kind of sophisticated testing. We had requested, since we were paying for it, that it be done by an independent lab that was nationally recognized or could sell more. But they were still arguing the DPS could do it, which would destroy the evidence and get us no results. And I said, Judge, oh no, we have come too far, we've fought too hard to get here. You can't do that. And having taken 2 for the team and been reversed twice, the judge gave me the first thing I want. In trial court, he said, okay, we'll have Orchid-Silmar tested. And we did. But there was a long queue for them because they were the best in the country. So we had to wait a long time for the results, and we finally got them in June of 2011. First result, bandanna, blood of Christine, sweat and skin cells of a man, not a woman, who is not Michael Morton. So, what's next? Run it through CODIS, the National Data Bank. August of 2011, almost 25 years to the day of Christine's murder. Hit confirmed, Mark Allen Norwood, a known felon with a record in 3 states of breaking and entering residences and assault with intent to murder. A long rap sheet of 30 years in length. We investigate where he lives at different times. You kind of track him by the places he's arrested in Tennessee, California, Texas. And we realize he's living in Austin, Texas at a certain time period of Christine's murder. Gone, came back again. There was a cold case website in Austin. Deborah Jan Baker, also bludgeoned to death in her bed, also a petite, attractive brunette in her early 30s with young children, also killed on the 13th of the month. 7/10 of them, no, less, a block and a half from where Mark Allen Norwood lived at the time. So Nina Morrison of the Innocence Project and I went to the Travis County DA and said, look, we've got some information for you. You've got this cold case on the website. This man lived really close by, and his DNA is on the bandana containing Christine's blood. We thought you might be interested. And they said, we are extremely interested, thank you. And they went to work. And they compared the DNA. And his pubic hair is found at the murder scene of Deborah Jan Baker. And so now he's under suspicion for that one. And so, I mean, I understand that he was a carpet cleaner, but unless he was the naked carpet cleaner, it's unlikely that his pubic hair would be there, and there'd be a good explanation for that. He's now being linked to others as well that are coming out. Meanwhile, we do a Freedom of Information Act request, and we find that concealed from the defense and the court at the time of trial were 3 significant items. 1, reports of a strange old van being sighted in the neighborhood days before the murder. We now know that Norwood drove an old van. And the man in the van would get out and look at the house, and he would walk around behind the house in the construction area where the bandana was found. The defense was never told about this, nor was the court. Now, you'll learn in law school that Brady v. Maryland, 1963, says that a prosecutor to turn over anything that might help a defendant. They're required by law to do that. That's the law of the land. And in addition, the court in this case had ordered the complete investigative file of the chief investigator to be produced to the court in camera so the court could review it to see whether it was Brady material. Was not produced. In addition to the van sightings, a transcript of the maternal grandmother of Eric, Christine's mother, talking to Eric a week after the murder, a little 3.5-year-old boy, and him and her describing in verbatim what he said to her, that the monster came into the house. A big man with a big mustache, which if you look at Norwood's mugshots then and now, that's what he is. Big old mustache going down. And he's hitting Mommy. Mommy's crying. Stop it. He's describing what he saw. Now Mommy stopped crying. The monster's mad. He put blue suitcase on Mommy. That's the way the cops found her. He had red hands. Blood. He's mad. And then they said, Eric, was Daddy home? No, me and Mommy. They knew that in 1987. They concealed it from the defense and from the court. And the final thing was that Christine's credit card was used 2 days after her murder in San Antonio, and there's an indication that it was under fraudulent circumstances. And there was no evidence that that was followed up on, and it was never concealed. That too was concealed. So we found all these things, and and by the way, so that you know, Mark Allen Norwood has now been arrested, charged, and indicted for the murder of Christine. So he is where he should be. But we're looking at these things, and we were always going to try to do it under two separate tracks: actual innocence of the DNA, but also due process violations for concealment of these Brady materials. Michael said, if I need to stay in prison while you investigate due process, that's okay. So this man, with all of his integrity, would have been willing to stay in prison several more months to allow us to take depositions to investigate due process violations. He's one of the bravest men I've ever known, and the best. Fortunately, it wasn't necessary. We were able to take these depositions, and we deposed Ken Anderson, we deposed prosecutors, we took sworn statements, and we presented them all to Judge Harrell, who was presiding by appointment of the Supreme Court, because the sitting judge, the one that I had to argue with so much to get the DNA testing, recused himself when he realized that the judge down the hall had concealed all of this. I need to be careful how I address it, because I do want to say this. Everybody's entitled to presumption of innocence. Mark Allen Norwood, Ken Anderson. Just because Michael Morton didn't get a fair trial doesn't mean that other people don't. We believe in that. Brave men and women have died for that. And everybody deserves their day in court. And Judge Anderson is about to get his, because by appointment of the Supreme Court, Judge Stearns out of Fort Worth has now been appointed to handle a court of inquiry to determine whether or not Ken Anderson violated the law, statutory law, in the way he handled Michael Morton's trial. And he may be facing indictment himself. First time, everybody says, first time anything like this has ever happened. So we're a little off the reservation as far as the law is concerned, but it's for a righteous cause. My wife Kelly and I had a blessed moment not too long ago in reintroducing Michael with his 28-year-old son that he hadn't seen in 15 years, and watching them hug each other and be father and son again. And I hope I'm permitted to say this. Eric and his lovely wife have had recently a little baby girl, and Michael is getting to be a granddaddy, and it's such a special time. I want to end with a call to action, and then I want to answer any questions you have. I worked hard. I was a good soldier at a big firm. I made partner. I left. I opened my own firm. I worked hard. I'm not saying that the things I did for my other clients, for remuneration, weren't meaningful and important. They were. They're certainly important to clients. But this case is the most satisfying case I've ever worked on. I urge you to do pro bono work when you get out. I sat right there 31 years ago and heard a man stand right here say that to me. And so now I'm passing the torch to you. Whatever you do pro bono work. There are lots of opportunities. There's volunteer lawyers associations. There's all sorts of things you can do. The bars have these opportunities. You must do it. You have to give back. And when you do, you'll see how satisfying and how important it is. My pastor told me that this is the most important case you'll ever work on in your career. I think he's right. Thanks for coming today. I'd be happy to answer any questions you have.
anybody out here can say that you owe your life to somebody. Think about that. Can you point to anybody and say that? My case was unusual, it's still unusual, but like John said, there will be, and there is, ample opportunity to do pro bono work. And I can only tell you what it's like to be on my side of the equation, but I can see what John has gone through and how it's changed him. When I first mentioned to him some of the odd, supernatural, weird hair on the back of your neck standing up instances about my case, to be candid, he kind of rolled his eyes at first. Yeah, right. But things happened and happened and happened that now he's fully on board. And I'll make this very, very brief because I know some of you are going to leave. But I just want to reiterate what John said is when the opportunity presents itself and you're asked to do some pro bono work or you just see the opportunity, please, please take it. Not for me or people like me, but for what it will do to you. It will change your life. Thank you.
Does anybody have any questions? A burning issue? Yes?
Maybe a call to arms question. And John Raley, here, we need you back on the rules of professional conduct committee, which is currently studying whether to amend Rule 3.8G and H of the ABA, of the Oklahoma Rules of Professional Conduct. The prosecutors, state and federal, have come out strongly against it. It's a very delicate issue that needs real wisdom. I hope in the audience is one of our students who's writing a paper on it. But so my question to you, besides my plea to your father, is have you studied 3.8G and H?
I have not, ma'am. I'm sorry. I'm just a Texas guy.
Well, and the Texas rules are unique unto themselves.
Sure, they are, such as they are. But I'll tell you, there are some things that they're trying to do in Texas, and there are legislative initiatives now requiring all district attorney files to be open to the defense. It's time. Most district attorneys with class do it already, but some don't. And you shouldn't oppose DNA testing. If it's the sort of thing that would be tested as part of law enforcement, if the murder happened today, but DNA was not available back then, it should be tested. Next question. Anybody? Joe? You want to take it? All right.
If I could, I realize we have a bell that will ring here very shortly. And before we all leave, I want to give really two gifts, if we could, to John Raley. If I'd known Michael Morton was going to be here to give you a gift, but I can't imagine one greater than your freedom. But thank you so much, John and Michael, for all you've done for us and for making all of us better and freer and for enhancing all of our liberties. We have two gifts. The first, which I'll not burden you with unwrapping right now, is a gift from your College of Law, which has the seal for the College of Law on a pewter dish. And thank you so much for all your support. And the second gift is really a gift to all of us, and it turns to this question that you've posed and the challenge that you've raised, which is who takes over, who assumes the torch for the work that you've been carrying. And what we'll do is, and we've already begun this, but we'll formally bring it in with this year's class and next year's class as well, is asking all first-year students to make a pledge when they first come to the College of Law to undertake to do 50 or 100 hours of pro bono and public service work while in the College of Law, and at graduation recognizing them with a crimson or a cream honor cord. If we could, before we leave, perfect timing, If we could, before we leave, let's please give John Raley and Michael Morton one final round of applause.